And good afternoon to everyone, depending on where you are. Welcome to this Helsinki Commission briefing on Russian crimes against Ukrainian civilians and findings from the OSCE Moscow Mechanism report. Russia has targeted Ukrainian civilians since its full-scale invasion of Ukraine in February 2022. There are numerous reports that civilians have been arbitrarily detained, illegally transferred, mistreated, tortured, and even killed as an apparent part of Putin's war strategy. Thousands have disappeared or are being held incommunicado. And while much of this has taken place since Russia's full-scale invasion of Ukraine in 2022, it also had been taking place since Russia's invasion of Ukraine in 2014. In February, 45 OSCE states, including the United States, invoked the Moscow Mechanism to initiate an internal investigation into the arbitrary deprivation of liberty of Ukrainian civilians by the Russian Federation. The resulting report was issued in April. The Moscow Mechanism is a tool agreed to in 1991 by all OSCE states to address a particular question or problem relating to human rights. It triggers an investigation and report conducted by vetted experts chosen from a standing list in order to ensure an unbiased product. The Moscow Mechanism has been invoked 4 times since February 2022 concerning Russia's war on Ukraine. The previous report was issued in May 2023 concerning the forcible transfer and/or deportation of Ukrainian children to the Russian Federation. Today, we will hear from the 3 Moscow Mechanism experts who conducted the investigation about their findings and recommendations. This will be followed by a question and answer session, so I invite you to type any questions for the experts into the chat box. So first, we'll hear from Professor Veronika Bilkova. She is the head of the Department of International Law at the Faculty of Law of the Charles University in Prague and senior researcher in the Center for International Law at the Institute of International Relations, as well as the head of the University Center for Conflict and Post-Conflict Studies. She's a member and vice president of the Venice Commission of the Council of Europe and of the Management Board of the EU Fundamental Rights Agency. She's been a member of all 4 Moscow Mechanism expert missions on Ukraine invoked since 2022. Her fields of research include the use of force, international humanitarian law, international human rights law, international criminal law, and the fight against terrorism. We'll then hear from Dr. Elina Steinerte. She's an academic and human rights lawyer with over 2 decades of experience. She's a member of the UN Subcommittee on Prevention of Torture and a former chair rapporteur and member of the UN Working Group on Arbitrary Detention. She has taught public international and human rights law at numerous universities in Latvia, the United Kingdom, and the Bailiwick of Jersey. The prime focus of her work and research has been the implementation of the United Nations Convention Against Torture and its optional protocol, and an array of issues surrounding deprivation of liberty, especially arbitrary deprivation of liberty. This is her 2nd time serving as a Moscow Mechanism expert. Then finally, we'll hear from Dr. Cecilia Hellestveit. She's a lawyer, social scientist, and senior researcher at the Norwegian Academy of International Law. She teaches and researches in the field of international law, use of force, and armed conflicts, and has authored numerous books on contemporary armed conflicts. She's a member of the Ethical Council of the Sovereign Norwegian Wealth Fund and a member of a governmental commission on extremism. She has worked on wars in the Middle East for almost 3 decades. She has also been affiliated with the Atlantic Council in Washington, D.C. This is also her 2nd time serving as a Moscow Mechanism expert. So with that, I would like to give the floor to Professor Bilkova.
Thank you very much for this kind introduction, and thank you very much for the invitation. Good morning, distinguished members of the U.S. Helsinki Commission. Good morning, good afternoon, or good evening, colleagues, ladies and gentlemen following us online. I am very pleased to have yet another opportunity to address you and to introduce, together with my colleagues, the most recent report on Ukraine issued under the OSCE Moscow Mechanism. As indicated by Mrs. Helvig, this is already the 4th report on Ukraine issued since the beginning of the full-scale invasion of Ukraine by the Russian Federation in February 2022. In all the 4 cases, the mechanism was activated by the highest number ever of the participating states in the history of the OSCE, that was 45 plus Ukraine, so almost all the states of the OSCE. The first two reports dealt with violations of international law in the conflict in the first 6 weeks and the subsequent 3 months, respectively. The third report, as already mentioned, focused on the forcible transfer and deportation of Ukrainian children to the Russian Federation. And the last, or for the moment last, and fourth report that we are discussing today concentrates on arbitrary deprivation of liberty of Ukrainian civilians by the Russian Federation and on violations of international law related to this practice. The report first establishes facts and then analyzes those facts in light of the applicable standards of international human rights law, international humanitarian law, international criminal law, and the OSCE commitments. All these 4 areas of law contain a clear prohibition of arbitrary deprivation of liberty. Such deprivation occurs when individuals are detained without their free consent, and such detention either lacks legal grounds or is conducted without adequate procedural guarantees, or both, obviously. Individuals subjected to arbitrary deprivation of liberty are moreover vulnerable to various other unlawful acts such as extrajudicial killings, enforced disappearance, torture, or sexual crimes. The mission established that since February 2014, a large number of Ukrainian civilians have been deprived of their liberty by the Russian Federation, acting either directly through its organs, especially its armed forces or the FSB, or between 2014 and 2022 through its proxies in the so-called Donetsk and Luhansk People's Republics. This practice has been documented in all Ukrainian regions which have got, for a shorter or longer period, under the temporary occupation of the Russian Federation. In fact, it seems to be one of the defining features of this occupation. When the Russians move into a certain area, they come with lists of people, such as journalists or human rights defenders, whom they immediately start to detain. They also pick up and detain random people in the streets, especially if these people look like they could have some link to the Ukrainian armed forces. The exact number of Ukrainian civilians detained by the Russian Federation is not known, but it highly likely ranks in the thousands, out of whom only a tiny minority have managed to escape or have been released. Those are the facts. I will now move to the legal analysis, or actually to the first part of the legal analysis. International human rights law and international humanitarian law establish certain grounds under which parties to an armed conflict may lawfully detain civilians belonging to the other party to the conflict. For instance, it is possible under Article 78 of the Geneva Convention 4 to intern the civilians in occupied territories for so-called imperative reasons of security. The mission, however, concluded that for the overwhelming majority of detained Ukrainian civilians, such grounds were not available, were not present. These civilians were mostly detained either because of their generous support for Ukraine and rejection of the Russian occupation, or to force them into cooperation with the occupying powers, or to spread fear in the population. All these reasons are unlawful under international law, and as a result, any deprivation of liberty based on them is arbitrary and unlawful as well. There were also instances where Ukrainian civilians were detained on account of their alleged affiliation to the Ukrainian armed forces or their alleged involvement in so-called extremist or terrorist acts. While such grounds could in principle, in theory, be lawful, evidence collected by the mission suggests that in most cases, these were mere pretexts, and the detention pursued other purposes, such as harassment or reprisals. This again renders detention unlawful and arbitrary. The absence of lawful grounds for the deprivation of liberty of Ukrainian civilians is further compounded by the unavailability of virtually all procedural guarantees that are foreseen under international standards. International human rights law and international humanitarian law both stipulate that detained persons, first, must be informed about the reasons for their detention. Second, must be provided with an opportunity to legally challenge the lawfulness of their detention, the so-called habeas corpus. Third, are entitled to periodic reviews of their detention. Fourth, must be provided with fair trial guarantees. And fifth, have the right that their state, their families, and certain other actors such as the ICRC, the International Committee of the Red Cross, be informed about their detention. Special guarantees also need to be provided to individuals belonging to vulnerable groups, such as children, for instance, and to persons enjoying privileges and immunities under international law, such as members of the OSCE staff. The mission established that none of these guarantees were truly available to the detained Ukrainian civilians. This unavailability in and of itself renders the detention unlawful and arbitrary. To conclude this section of the presentation, which will be obviously followed by my colleagues, the mission established that thousands of Ukrainian civilians have been arbitrarily deprived of their liberty by the Russian Federation. This practice constitutes a clear violation of international human rights law, international humanitarian law, and the OSCE commitments. It also highly likely amounts to the war crime of unlawful confinement of protected persons under Article 147 of the Geneva Convention 4, and, due to its massive, widespread, and systematic nature, to a crime against humanity, namely the crime of imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law under Article 7(1)(e) of the Rome Statute of the ICC. Thank you for your attention, and now my colleagues will inform you about our findings related to the treatment of the detained civilians and to their post-detention situation, and I will obviously be very happy to address any questions that you might have. Thank you.
Thank you so much. And now I will give the floor to Dr. Steinote.
Thank you very much, Mrs. Helwig. Thank you, Professor Bilkova. Good morning and good afternoon, ladies and gentlemen. Thank you to the US Helsinki Commission for this event and for the opportunity to present a very brief summary of the findings of this latest Moscow mechanism mission concerning the treatment of Ukrainian civilians arbitrarily deprived of their liberty by Russia. I shall also make brief comments on the accountability mechanisms in this regard. Both IHL, the International Humanitarian Law, and International Human Rights Law foresee quite a comprehensive legal regime applicable to treatment of civilians detained in the context of an armed conflict. While the treatment of the Ukrainian civilians detained by Russia is not the prime focus of the mandate of the mission, it is impossible to examine the phenomena without also looking into the treatment that such civilians have endured and most likely continue to endure as I speak. Moreover, it must be underscored that in some instances the treatment subsequent to the detention may affect the status of that detention, rendering it arbitrary. From the outset, let me recall that the obligation of the state to treat everyone it has deprived of their liberty with humanity and with respect for the inherent dignity of the human person is encapsulated in Article 10 of the International Covenant on Civil and Political Rights, and this applies to all forms and all places of detention. This is a positive obligation imposed in relation to persons who, because of their status as persons deprived of liberty, are in situations of particular vulnerability, and this obligation is nowadays considered to be non-derogable in nature. It is also one that Russia has not even attempted to derogate from, even when its obligations under the ICCPR were considered by the Human Rights Committee as late as December 2022. The obligation of humane treatment is an overarching concept, and there are certain acts which are clearly incompatible with this obligation. These especially include extrajudicial killings, torture, and other cruel, inhuman, degrading treatment or punishment, certainly as well as various forms of sexual violence, including rape. Ladies and gentlemen, the mission concluded with regret that Ukrainian civilians arbitrarily deprived of their liberty by Russian Federation have been, on a large scale, subjected to precisely such practices as extrajudicial killings, torture, and other cruel, inhuman, or degrading treatment and punishment, sexual violence, and the denial of the very basic fair trial guarantees. What the mission saw was that upon detention, civilians are exposed to regular mistreatment involving torture and sexual violence calculated to bring about humiliation, forced confessions, and subjugate and scare people into submission to and cooperation with the occupying forces. They are denied any contact with outside world, including their families. They have to endure harsh conditions as they are often held in unofficial makeshift places of detention, which sometimes are nothing more than holes dug in the ground, and subjected to violent, punitive regimes whereby they are required to obey impossible rules, whereby placing a cup in the wrong place, or indeed speaking Ukrainian among themselves, would lead to most severe beatings. They are denied food and water, and those families who have been fortunate enough to somehow locate their loved ones desperately seek ways of engaging with Russia's prison system online shops to ensure that those detained get at least some food, no matter the at times 100% markups to the prices which are imposed. The detained civilians are denied medical assistance, not only assistance for chronic conditions, but even emergency assistance, which at times has been required following the very treatment these individuals have endured at the hands of their captors. People are forced to sleep on cold floors without mattresses and bedding. That is, of course, if the overcrowding situations allow them any space to lie down at all. The conditions of detention are unhygienic, they lack basic sanitation, and there is often no proper ventilation or light, let alone possibilities to go out in fresh air. The total denial of contacts with the outside world has resulted in Ukrainian civilians being held incommunicado and even being subjected to enforced disappearances, thus also forcing whole families into the state of victimhood, desperate for any news of their relatives, which in many cases now already exceeds 2 years. Regrettably, arbitrary deprivation of liberty of some Ukrainian civilians has also cost the ultimate price, that of their life, as the mission has recorded cases of extrajudicial killings. For others, arbitrary deprivation of liberty has meant total denial of the most fundamental fair trial guarantees. Ukrainian civilians are tried under legislation which should not apply to them in the first place, in violation of the principle of legality and retroactivity. Their procedural rights and the right to defense and legal assistance are not respected. And the mission recalls that denial of fundamental fair trial guarantees renders in and of itself any detention related to criminal prosecution arbitrary. Dear audience of the present event, the widespread nature of torture and sexual violence, and therefore the severity of violations of international humanitarian law and international human rights law associated with this, has led the mission to draw the attention of all states to the various international human rights mechanisms that could provide redress. While the full report at your disposal examines a number of such, I would like to very briefly highlight only 3. Firstly, it is the procedure under Article 30 of the United Nations Convention Against Torture, which is a de facto dispute settlement mechanism in cases of, and I quote, any dispute between two or more states parties concerning the interpretation of application of this convention, Convention Against Torture, which cannot be settled through negotiations. End quote. In such cases, if agreement cannot be reached within 6 months, any of those states parties may refer the dispute to the International Court of Justice, and this is a procedure that is available to all states parties to Convention Against Torture, including Ukraine, including Russia, including USA. Secondly, let me briefly highlight the two UN special procedures, the Working Group on Arbitrary Detention and the Working Group on Involuntary and Enforced Disappearances. These mechanisms, because they derive their mandate from the UN Charter through the Human Rights Council, have the mandate to engage with the situations pertinent to their respective mandates wherever on the globe these would happen. And the mission documented a number of cases of torture, as I already noted, as well as those of involuntary and enforced disappearances. And in the case of Working Group on Arbitrary Detention, there is also a quasi-judicial function to the mandate, which can and should be utilized. Dear colleagues, friends, to conclude my part of the intervention in the event today, the mission has established that the practices of extrajudicial killings, torture, and other cruel and inhuman and degrading treatment or punishment, sexual violence, and the denial of fair trial guarantees have been pervasive in the course of the deprivation of liberty of Ukrainian civilians, both in the initial stage and during protracted detention by the Russian Federation. These are grave violations of international law, which regrettably the world has seen before, leading to the calls of never again. And yet, here we are again, with never again promise unfulfilled. There is, however, a possibility to change that, and the mission urges all, be these states, organizations, intergovernmental or non-governmental organizations, or indeed individuals, to do just so. I thank you, and I pass on to my colleagues and look forward to our discussion at the end. Thank you.
Thank you very much, and especially for the recommendations on potential redress. So now I will give the floor to Dr. Hellestvit.
Thank you very much, Ms. Helvig, and to my colleagues. Thank you so much for the kind introduction and for the opportunity to present the report and our recommendations and discuss its various topics with this distinguished audience. Ladies and gentlemen, I will present some additional findings linked to the Ukrainian civilians arbitrarily deprived of their liberty by the Russian Federation, and I will then give you a brief summary of the recommendations of the missions. If civilians are detained in line with international humanitarian law and international human rights law, there are some avenues for the release of these civilians. This is not the case here. There is only one legally correct solution to the arbitrary detention by the Russian Federation of Ukrainian civilians, and it is immediate and unconditional release. But since the Russian Federation does not release them in line with the obligations, the Ukrainian civilians arbitrarily detained are left in an extremely vulnerable situation. They are exposed to other violations of international humanitarian law, also in relations to their own release. So in the course of our examinations, the mission has learned that in some cases of release of Ukrainian civilians from arbitrary detention, the detaining power, Russia, has set conditions of release that are in themselves violations of international humanitarian law. The mission has come across release in exchange for ransom money amounting to hostage taking. We have encountered cases where the conditions of release amounts to de facto deportation in blatant violation of international humanitarian law. And some Ukrainian civilians arbitrarily detained by the Russian Federation have been delivered to Ukraine in exchange for Russian prisoners of war, meaning soldiers then in exchange for civilians, which is also a clear violation of the system envisaged by the 4 Geneva Conventions. Further, the mission has been informed about disturbing cases where conditions of release of Ukrainian civilians arbitrarily detained include forced declarations of allegiance to the enemy power Russia, forced confessions concerning past collaboration with Russia, and signatures of confession on blank paper to be filled out later by the detaining power Russia, and other similar conditions of self-incrimination as conditions for release. So these conditions set by the detaining power are all violations of IHL in and of themselves, and some amount to war crimes. And they add further gravity to the practice of arbitrary detention of Ukrainian civilians by the Russian Federation. So on a more general note, under international humanitarian law, civilians in the hands of the enemy belligerent are victims of war. And the harrowing experiences of the Second World War led states in the world to conclude the Fourth Geneva Convention in 1949, a major legal heritage of the largest war of the 20th century. The Geneva Conventions, all four Geneva Conventions, are ratified by all states in the world. And the purpose of these rules is to protect victims of war against retributions or other excesses associated with full interstate war. The provisions of the Fourth Geneva Conventions aim to prevent black sites where civilians are held incommunicado in inhumane conditions. These rules seek to ease the scourges of war by providing families with information about the fate and whereabouts of their loved ones. And most importantly, these obligations of international law have the purpose to protect civilians and prevent civilian victims of war who find themselves in the hands of the enemy belligerent from becoming instruments for the enemy power, serving as tools for the political or military objectives of the enemy. And the distressing findings of the mission is that the Russian Federation does not seem to abide by the provisions of the Fourth Geneva Convention with respect to Ukrainian civilians who are victims of war and who find themselves arbitrarily detained by the Russian Federation. So the findings of the mission has led the mission to draw attention to a practice that has been out of use for generations and that has thus far not been put in place in this conflict, namely the Institute of Protecting Powers. Protecting powers are third states, not parties to the armed conflict, but designated by one of the belligerent parties to the conflict and accepted by the other belligerent party to the conflict, and tasked to safeguard the interests of the former party and of its citizens, including civilians in the hands of the enemy party. The Geneva Conventions explicitly mention protecting powers and attribute some tasks to them. And the massive scale of the conflict in Ukraine, as well as the systematic and widespread nature of violations of international humanitarian law, including numerous instances of arbitrary deprivation of liberty of Ukrainian civilians, give reason to consider the establishment of protecting powers in order to strengthen the mechanisms to ensure compliance with the rules and obligations in place to protect victims of war, including civilian detainees. Ladies and gentlemen, I will now end my presentation by providing a short summary of the 5 most important recommendations of the mission. And while the mission has provided a number of recommendations to the Russian Federation, to Ukraine, to third states, and to international organizations, I will focus on the 5 most important recommendations to the Russian Federation. First, to cease the practice of arbitrary deprivation of liberty of Ukrainian civilians and to unconditionally release all those thus detained. Second, to facilitate the safe release, return to place of residence, accommodation in third countries, or repatriation of the arbitrarily detained Ukrainian civilians. Third, to provide Ukrainian civilians deprived of liberty with procedural guarantees foreseen by international humanitarian law and international human rights law, and ensure that all detained Ukrainian civilians are treated in a manner respectful of their inherent dignity, held in humane conditions, and afforded full fair trial guarantees. Fourth, ensure immediate, safe, and unfettered access for the ICRC to all facilities where Ukrainian civilians are being detained, both in the temporarily occupied territories and in the Russian Federation. And fifth, ensure the right of those subjected to arbitrary deprivation of liberty and their relatives to an effective remedy, including cessation of violations, restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. And with that, I end the presentation of the mission, and thank you for your attention, and I will be happy to answer any comments or questions that you may have.
Thank you so much. Before we go to our discussion, I would like to give the floor to Mr. Alexander Maznichenko for some comments. And again, if you have any questions for the experts, please type them in the chat box. So Mr. Maznichenko is a Ukrainian diplomat with over 20 years of professional experience in multilateral diplomacy, human rights, and international law. Cooperation with the OSCE has become central to his diplomatic activities, starting with Ukraine's OSCE chairpersonship in 2013. Currently, he holds the position of counselor at the Ukrainian delegation to the OSCE in Vienna. He has played one of the leading roles in building support for the invocation of all OSCE Moscow mechanism since Russia's full-scale invasion of Ukraine. With that, Alexander, I will turn the floor to you.
Thank you very much, Madam Moderator, dear Janice, for your kind words of introduction. Esteemed experts, Professor Bilkova, Dr. Steinerte, and Dr. Hellestweit, distinguished audience. At the outset, I would like to thank the US Helsinki Commission for organizing this important event, and it is an honor for me to contribute to our today's discussion. It is vital for the sake of both justice and accountability to continue shedding light on the violations of international humanitarian and human rights law, war crimes, and crimes against humanity perpetrated by the Russian Federation amidst its war of aggression against Ukraine. The arbitrary deprivation of liberty of Ukrainian civilians by the Russian Federation is one of such most serious international crimes. In order to address this extremely grave situation, which endangers life and health of thousands of Ukrainian citizens, President Volodymyr Zelensky's peace formula contains a special point according to which the international platform for the release of civilians illegally detained by Russia has been established to consolidate international efforts on this track. I take this opportunity to reiterate Ukraine's gratitude to the distinguished experts for the preparation of the independent international report on the issue following the relevant request by 46 OSCE participating states. You have accomplished a significant work, and we highly value that the mission was able to visit Ukraine in March to meet with the representatives of Ukrainian authorities, NGOs, civil society, as well as victims and witnesses, to gather first-hand information on the ground. The Minister for Foreign Affairs of Ukraine, Dmytro Kuleba, welcomed the report and stated, I quote, "The conclusions of the mission are shocking and should be an alarm signal for the world community regarding Russia's deprivation of liberty of civilian hostages and the importance of their immediate release," end of quote. The report contains a number of important findings and conclusions which we just heard from the presentations of distinguished experts. Among them, the fact that the practice of arbitrary deprivation of liberty of Ukrainian civilians has occurred on a massive scale and has signs of a systematic, consistent, deliberate pattern of conduct targeting specifically Ukrainian civilians. It started in the occupied Crimea in 2014 and has been further perpetrated by the aggressor state since the full-scale invasion of Ukraine in 2022. Ukraine finds it critically important that the conclusions of the report can be used within the framework of a national and international mechanism for bringing to justice the war criminals of the aggressor state, and also because the conclusion of the report may contribute to the achievements of the goals of the Ukrainian this formal offers release of all captured and deported persons. And this clearly requires united and coordinated efforts of states and international community. Let me conclude my remarks by reiterating Ukraine's call on the international community to further actively use and spread the Moscow Mechanism mission conclusions, as well as to consolidate efforts to ensure the immediate and unconditional release of all Ukrainian civilians arbitrarily detained by Russia. And also, with your permission, Madam Moderator, if I may, I would like to address two questions to the experts. So first, your mission established that Russia's actions against arbitrarily detained Ukrainian civilians may amount to such war crimes and crimes against humanity as first, unlawful confinement, second, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, third, extrajudicial killings and the failure to investigate properly allegations of such killings, and fourth, widespread and systemic use of torture. Could you kindly elaborate a bit more in detail on these findings, taking into account the importance in terms of supporting the work of national and international judicial bodies to identify concrete individuals who should be held criminally responsible for those crimes? And second question is related to the mission that mission pointed out, in fact, that not only the parties to the conflict, but also all other states have the obligation to ensure respect for international humanitarian law and the obligation to prevent, repress, investigate, and prosecute war crimes and crimes against humanity. I would be keen to hear your view on the most appropriate ways and settings to implement such steps. I thank you very much.
Thank you very much, Alexander. And I will now turn to our experts to answer these questions. I think, Professor Bilkova, perhaps you would start.
With pleasure, but I would first like to thank Mr. Maznichenko for his kind words and also for all the help and support provided to the mission in the course of its work, which was truly invaluable. I will start addressing the first question, and then I will leave it up to my colleagues, obviously, to add other issues and to address the second question. So the mission was asked to focus on two very different types of violations of international law. On the one hand, these are violations of international humanitarian law and violations of international human rights law. And on the other hand, there were war crimes and crimes against humanity. And the mission was clearly better equipped to focus on the first category, and also we came to more categorical conclusions on this one. And let me explain why. So the first category, violations of international humanitarian law and international human rights law, are violations committed by states. So these are, the actors are relatively easy to identify because there is a limited number of states involved in armed conflicts. At the same time, there is a big number of potential violations that states may or can commit, not may, can commit in the course of an armed conflict. And also the standard of proof is relatively low. We applied the reasonable grounds to believe standard. That make it relatively easy for us to conclude that indeed the Russian Federation, by detaining Ukrainian civilians without legal grounds and without procedural guarantees, and by subjecting them to all these mistreatments described by my colleagues, has indeed committed clear violations of international humanitarian law and international human rights law. Now, moving to the second category, war crimes and crimes against humanity, on the contrary, are committed by concrete individuals. And while we have only 2 states fighting in Ukraine, we have thousands and dozens of and hundreds of thousands of people present. And obviously, within the 3 weeks reserved for the mandate, we were not able to identify specific persons who would be responsible for the crimes. At the same time, the number of war crimes and crimes against humanity is more limited, and the standard of proof is much higher, because this is a classical criminal law standard, which is the standard beyond reasonable doubt. It is impossible for a mission of experts, a fact-finding mission, which moreover only has 3 weeks at its disposal, to really go through the whole criminal procedure to identify the persons and to go through all steps of the regular fair trial. That is why we say that there is a high probability that war crimes and crimes against humanity have been committed, but we do not name anyone. This is for criminal bodies, both at the national level and at the international level, such as the International Criminal Court, to really continue the work. We know that such investigations, both in Ukraine, in other countries, and at the international level, are ongoing. And we believe that our report could serve as one of the many sources of information for them, but obviously in and of itself, it is not sufficient to serve as the basis for criminal prosecution. I hope that answers the question, but I'm sure if it does not, my colleagues will add elements that will make it completely clear.
Thank you. And who else would like to respond?
I'm happy to jump in on perhaps on the second question that was posed in relation to the criminal prosecutions and what the states could do. Well, as Professor Bilkova already mentioned, in terms of the international criminal law, of course, we have the International Criminal Court. And now we have already 2 sets of arrest warrants that, well, one has been issued, the others are still in the process. So we know that in March 2023, 2 arrest warrants were issued, and then again in March this year, another 2 arrest warrants were issued in relation to individuals from Russia in relation to the ongoing war in Ukraine. And of course, we also, I think, can only imagine that further work is ongoing by the prosecutors, and further arrest warrants could be expected. And of course, I think it is very important for all states to remember that it's important to support these efforts of the ICC and of the prosecutors, but also equally important to let these prosecutions and these investigations to run their course and give the time and space with the support that is required for this to be conducted properly, so that international criminal law standards can be satisfied. Having said that, I think it is also very important for the states to remember that their own national criminal jurisdictions, their own national criminal legislation quite often provides a legal framework which can and should be utilized in parallel in order to provide redress to the individuals in cases of arbitrary deprivation of liberty, in cases of torture, extrajudicial killings, sexual violence, etc., etc. Indeed, as we know, criminal jurisdiction in states, in any country, usually we have as a basis of jurisdiction, if the crime has been committed on the soil, on the ground of the state, then the state usually would exercise the jurisdiction. That's the most common construct in criminal law. But there are also 3 other possibilities. So one possibility is when the perpetrator of the crime is the national of the state, or the victim of the crime is the national of the state. That also gives the possibility for the state to exercise their jurisdiction. But there are also a set of rules in international law, and to make things a little bit perhaps simplistic, it is something that's called universal jurisdiction that I'm sure many in the audience have heard about and know about in great detail. But to make things simple, the international community has, as a whole, basically decided that there are certain crimes which are just so abhorrent that it doesn't matter who committed them, where they were committed, they simply must be prosecuted, because there should be no safe haven anywhere in this world for people who engage in such most horrendous practices. And torture is the prime example of such heinous crimes, as is enforced disappearances. And we already have some examples of this provision of universal jurisdiction being exercised about 6 weeks or so ago. I'm sure everybody heard of a very famous case where the universal jurisdiction was invoked in court in Buenos Aires by Ukrainian civilian, precisely alleging arbitrary deprivation of liberty and torture by Russian armed forces. And that happened quite far away from Ukraine in terms of geographic location. But the victim, the alleged victim, was present in the country and was utilizing this jurisdiction, the possibility of Argentine criminal legislation provided by Argentine criminal legislation. And I think it is clear that Argentina is not the only country in the world that has such legal provisions. Other states could be following the suit. And talking in front of the audience from the country which has given the world jurisdiction or the world law in terms of torture prevention and protection, the most incredible case law in relation to the prosecution under universal jurisdiction. So there are ways how national criminal jurisdiction as well as tort jurisdiction and tort law can be utilized and should be utilized for these prosecutions. Thank you.
Thank you. And Dr. Hellestveit, would you like to add something?
Yes, thank you very much, Janice. I'll just have a couple of added comments. Under the Article 1 of the 4 Geneva Conventions, which then is ratified by all states in the world, there is an obligation not only to respect IHL, but also to ensure respect for IHL. And I think there is this common interest among all states in the world to make sure that major military powers do actually respect the treaty obligations that came out of the Second World War. I think that there is an added layer here of interest among all state parties to the Geneva Conventions, that a state is not getting away with only relating to 3 out of the 4. So there is this argument of putting pressure on Russia actually to relate to the fact that the 4th Geneva Convention apply de jure to this armed conflict, irrespective of what Russia would like to be the case. So I do think that and this is some of the added value, I believe, of the report, because it doesn't really go into the specific cases of war crimes, but it does look at the systemic nature of these violations. It looks at the lack of legal grounds all over, the lack of safeguards, the unlawful treatment, and the added violations of international law as a consequence of the situation of these victims of war. And I do believe that this systemic position of the civilian Ukrainians in the hands of the Russian Federation is basically to the core a question about the lack of the Russian Federation not relating to its obligations under the 4th Geneva Convention. So I do believe that there is also a rather strong interest by all states in the world to ensure that Russia really can comply with its obligations.
Thank you very much. I have a question in the chat concerning Russia's response to your report and recommendations. And of course, as part of an annex to the report is your letter requesting to the Russian government information. And of course, for the audience, the report is also discussed in the OSCE in the Permanent Council, which is an ambassador level meeting that takes place once a week where Russia is normally represented. So could any of you speak to the Russian response? Dr. Vilkova?
Thank you very much for the question. It has 2 aspects to it, this question. The first one relates to the response or lack of it to the original letter, and the second one to the reaction of the Russian Federation to the report itself. So first, when the mission was established, we sent, in line with our usual practice, two letters, one to the permanent mission of Ukraine and the other to the permanent mission of the Russian Federation, because these were the two countries which were highly probable of having some information that would be useful for the mission. We received a letter or a reply from the permanent mission of Ukraine, which is also attached to our report, and Ukraine then also in line with the information in the report, in the letter, provided cooperation. We did not receive any reply from the Russian Federation, so the response to the letter was silence. Concerning the presentation, so the report was presented to the Permanent Council, and the Russian Federation was present, and it has its representatives present during this presentation. Its reaction to the report was not a positive one. The Russian Federation believes that the Moscow mechanism is, for different reasons, not an appropriate tool to address the type of events we witness in the conflict in Ukraine. The Russian Federation did not engage and did not comment upon the substantive findings of the report. It simply stuck to the procedure and personal aspect of the whole procedure, just saying that the Moscow mechanism is not appropriate, and the actors involved were not the best place to consider this issue, just to stay on a very general and polite level.
Thank you. Could I ask also a bit about the scope of detainees? Because we hear various numbers. We have categories, people who are arbitrarily detained, but we also have enforced disappearances or people held incommunicado. And in many areas, particularly I'm thinking in 2022 of Mariupol, where it may be hard to know who went through a filtration process and was detained versus who may simply have been killed in the bombing. What do we know about the numbers, the scale, how many people may have been killed versus disappeared? And do you think that the Russian Federation itself knows? Do they actually have a good list? Do you think that they are tracking it themselves in any kind of a central way? Who would like to address that one?
Shall I give it a go?
Please.
Turn then. Indeed, when it comes down to numbers, this is one of the most challenging questions that there is. It is absolutely legitimate question. It's without a doubt. But also, I think what is very important is that when we ask this question, I think we tend to forget about the fact that we are talking about active war zone and situation that has been like that, not only for the past 2 years, but actually since 2014. And that makes things exceptionally difficult when it comes down to tracking numbers and talking about very precise numbers. This is why Professor Bilkova in her introduction, when she spoke of the factual elements, spoke that we didn't put a precise number, but we are quite certain that we are talking about thousands here. And let me give you an example, and you yourself already, Mrs. Helwig, when you were asking this question, giving example of Mariupol, how challenging it is. So if I am a mother and my child is missing, in the situation of active warfare, where could this child be? Could this child be hiding somewhere? Could this child be injured and be in a hospital and unable to tell where he or she is? Could somebody taken in this child to help in a shelter this child? Or could this child be taken away by the Russian forces? So these scenarios are endless. So what happens in this situation, what we see is that people would, when they are able, finally, would go and report, whether they would report it to a civil society organization who in most instances would direct the people to police to report this to police. The police are, again, in the midst of everything else. They have to deal in a situation of active war zone and trying to maintain the civil side of law and peace and good order in whichever way in the city we are talking about. They would take this information, and most likely this would all go in the same pot. Be this person missing, presumed dead, unknown location, runaway, we don't know. And all of this information is collated together. What we then see in relation to arbitrary deprivation of liberty and those individuals, those Ukrainian civilians who have been subjected to the practice, in most instances is that the family members start, what I apologize for such a way of describing, they start the walkabout. They start trying to find out from which authority, where, who might have heard anything at all about anyone all of a sudden appearing in some facility that the Russian forces are holding. Trying to talk to those who have been and somehow have managed to free themselves from the captivity, trying to locate, trying to write letters of requests to various Russian authorities. And quite often it is quite literally looking for a needle in a haystack and just trying, with various targeted or less targeted, just casting the net wide and trying to locate where the individuals might be. And that makes things exceptionally difficult. From the Ukrainian side, what we see is now from the beginning of this year, a very concerted effort to try and centralize all of this information from various sources. So within the Ministry of Foreign Affairs, within, Internal Affairs, from the police, from the prosecutor's office, trying to centralize this all information so that there is at least one central point of information, point of call for individuals who can come and say, my brother is missing, my father is missing, my mother is missing, my child's missing, etc. And then trying to start piecing this information together from there. But it's very, very difficult because you also have constantly ongoing warfare, which makes anything in the country exceptionally difficult. Now, you also asked about question about Russia and whether Russia has these numbers. I think it would be a speculation, do they, don't they? But what is very clear is that they ought to. That is without a doubt. And it is not just something that I say because I believe so. It is actually their obligation under Geneva Conventions and under international human rights law. If they don't, then these obligations fall. They must have it. You cannot take somebody in custody and not know who that is. We know that under civilian law in the day-to-day practice, and that is absolutely the same provision applies also in cases of war. Thank you.
Perhaps I might add a little
Please,
bit to what my colleague has stated. Now, the Fourth Geneva Conventions has exactly this objective of obliging the enemy belligerent power to assemble information about enemy civilians and others and children and POWs that they have in their hands, precisely because the Ukrainians do not have access to these areas. Therefore, the enemy belligerent power has an obligation to make sure that these pieces of information are gathered and then transferred back. And of course, given this systemic absence of this system, that leads to an added uncertainty about the numbers. So basically, if the Russians had been complying with the Fourth Geneva Conventions, we would have much more reliable numbers. This goes for the civilians, and it also goes for the deported children. So basically, this absence of this system provides a lot of problems for the Ukrainian state, for the Ukrainian families, for the mechanisms that are supposed to work under the four Geneva Conventions, taking care of individuals who are victims of this war and who find themselves in the hands of the enemy. Now, when this system doesn't work, what we have seen in our work is that on the Russian side, there are certain parts of this puzzle that are being catered to by, for instance, the Red Cross locally in Russia or other institutions, but it's not, we haven't been able to identify one system when it comes to tracking who are the civilians who are detained by the Russian Federation linked to the armed conflict. Where are they? What is their fate, and so forth. We have not been able to identify that. Now, that doesn't mean that it doesn't exist, but we have been looking quite intensely, and we have not been able to identify it. Please, if you want to comment, Veronica.
No, I think the answers provided have been sufficient. I'll just add one sentence, namely that the lack of cooperation of the Russian Federation with respect to the mission has not been helpful in this respect, quite obviously.
Thank you. Let me ask about a specific case, if I may, that is mentioned in the report, and that has to do also with another category you discussed, which is detainees who were not provided due process, fair trials, knowing the charges against them. And that is of the OSCE staff members who worked in Ukraine in the special monitoring mission, because I think it's worth mentioning some very specific people that worked for the OSCE. Could you talk a little bit about that case and why you concluded that it was an arbitrary detention? I'm not sure who would like to take that.
Are you pointing towards me, Veronica?
Okay.
Yeah, I don't want to monopolize the discussion.
No, I mean, very briefly. So what is very clear in this connection is that the individuals in question were arrested precisely because they were doing their job. And they were doing the job, which was international monitoring a mission of the international organization. Now, leaving aside that in this case, we also can talk about the privileges and immunities that apply to the staff of the OSCE, of which organization Russia is a state party. So therefore, if we actually look, it turns out rather absurd situation. On one hand, Russia was part of the organization which mandated these individuals to carry out the mission. And then with the other hand, it was pulling them back and saying, well, actually, you have committed something illegal in the country. The absurdity, I think, is plain to see in these actions. But leaving that to one side, in this instance, we are talking about individuals who are implementing an international mandate, who are under the protection of the international mandate. And for the very fact of doing this, implementing this international mandate, they were arrested, they were charged, and they have been subsequently prosecuted under the legislation which clearly didn't even apply to them. So the situation here, even without going into the details of individual cases, is plain to see. Under international law, this is arbitrary deprivation of liberty without doubt.
Thank you very much. I think we have time maybe for one more question. And what I'd like to ask is about redress and compensation, which is another area that's discussed in the report. We've talked about the difficulty in gathering data and cases. So I'm wondering, the Council of Europe has a database collecting damages. I'm wondering, could that have some kind of a role? And should post-conflict planning, should that be taking into account also when we look at, for example, using frozen Russian assets as compensation, something like that? Should that be taken into account in terms of compensation to survivors of arbitrary detention? Who would like to take that question? Dr. Bilkova?
Okay, then I will. There is also one more question in the chat, if I may start with that one, just not to overlook it. It's about repeated deprivation of liberty. we indeed were able to identify cases where people were repeatedly deprived of their liberty, and very often it was not even after the change of the regime of the territory or of the control of the territory, but people were sometimes detained, kept in custody for some time, then they managed to escape, or they were even exceptionally released, but after some time they were detained again, and in most cases they did not even know why this was happening. So this is something that occurs, and that occurs quite frequently. So that for this question. And now about the compensation, this is indeed a very complicated debate, and the compensation mechanism is still being construed, because also the scale of damage, and we speak about different types of damage. Obviously, it's personal damage, it's material damage, it's financial damage, etc., is enormous. So for the moment, what we have at the Council of Europe level is indeed this register. But as the title indicates, the purpose of this register is merely to register. That means it's a collection of data that should be used in future once the compensation mechanism will be put in place, and once there will be a body which will actually decide on individual instances of damage and will potentially assign some compensation. What this body would be like, how it will act, and which funds will be used is still to be determined. There are obviously some proposals put on the table, including the one to use either the Russian frozen assets, or at least the interests coming from these assets. But then it opens a whole lot of questions, political questions, but also legal questions. What type of property, for instance, or frozen assets can be used? Could it be private frozen assets? Could it be state, Russian Federation's frozen assets? Does the immunity apply or not? So it's still something that has been actively discussed since the very beginning of this full-scale conflict, but where we are only in one of the first stages with this register of damage.
Thank you. Would anyone else like to make Dr. Steinerte?
Just a very small comment to just complement what Professor Belkova here said, though, that this register, though, yes, it is just a register, but it's such a crucial step. Let us not forget that for something to happen down the line, these initial steps are so paramount, and it's so important to get them right, and it's so important to get the procedures right. And I think this is very important to acknowledge that it's not also something that can happen overnight. We are talking about very, very complex situations. And when it comes to register, again, we are going back to those situations that I kind of imaginatory scenario I was presenting about registering the numbers. Again, we are back to that situation, how these individuals actually can access that register, how to make it work. So I think it is very important here to take that note of just how significant establishment of this register is for the future steps that absolutely need to follow.
Thank you so much. Well, I think we're just about out of time. I just wanted to ask if there was anyone who wanted to make a final comment, including you, Alexandra, if anyone wanted to, if there was something that we left out you would like to add. If not, I will just thank you all so much, both for being with us today and also for your report, for your work. It was really excellent and very, very valuable. And the recommendations, I know we will all be using and figuring out more follow-up for them. Thank you so, so much.
If I may, very briefly, I just wanted to thank you for this event. And I also wanted to say how important events like this are. There is a lot of information and misinformation around a lot of issues that the report is touching upon. And I think it is absolutely crucial that this debate takes place, but it takes place in a learned way and through established practices. And I think the Moscow mechanism, even if I, as one of the experts, do say so myself, there is the credibility. The OSCE is the only organization that has this series of, you could say, series of reports, but they are thoroughly investigated, grounded in international law. and also grounded into facts. We did go to Ukraine, we did speak to victims, we did collect testimonies, and that is something that speaks for itself.
If I may also take a floor just for a minute, I would also like to thank the US Helsinki Commission for this opportunity. And I would also like to thank all those who have attended this meeting or who have followed us in whatever way. And I would have a request for you, please read the report, or at least if it's too long for someone, at least the executive summary and the recommendations. And not only that, bring the report and the recommendations to the attention of your respective, in your respective countries, to the media, to the politicians, because it's very important that the recommendations and the findings do not only remain on a paper, but are really brought into practice. Thank you.
Also, just a final word of gratitude from me. I echo what my colleagues have said, and just one final observation. I must say I've been working with armed conflict for many years, and the type of treatment that the Ukrainian civilians are receiving in Russian detention was rather shocking to me, I must say. And this is ongoing. These are ongoing violations. So I do hope that you can make use of the report so that this contributes to a change of that situation.
Thank you very much. And I think that's a very good point to end on, that these crimes, this mistreatment of detainees is still going on. And that's why it's so important. Thank you very, very much. Thank you, everyone.
If I may, I would like also to
Sure.
to join colleagues and thank you for organizing this important event on promoting the very important findings of the report, but also keeping high on the agenda this critical human rights issue, because it's all about human dignity and human lives. And I would like also to take this opportunity to sincerely thank all three experts for their professionalism, for their courage in implementing their mandates, and also for their dedicated efforts in remaining seized of this matter and in promoting this important issue. Thank you.
Thank you so much. Thank you, everyone. Bye.
Thank you.
Thank you.
Recording stopped.